The judgment by Judge Elias Mathojane means former President Jacob Zuma will remain on medical parole and that the matter can be heard at the country's Supreme Court of Appeal. But before the judge made that ruling, the lawyers representing the Democratic Alliance, the Helen Suzman Foundation and AfriForum strongly opposed Zuma's bid. They argued that the appeal does not stand a reasonable chance of succeeding and that the former president has in fact better medical care inside prison than outside.
Mr. Zuma, while incarcerated, had full access, as we know from the record, to the best possible medical care in prison. He had the assistance, he had nurses assigned to him, he had the assistance of medical practitioners from the Military Health Service, and he was being optimally managed in prison. Perversely, now that he's been released on medical parole, he has been released to Nkandla in the care of his wife, who has no medical training or expertise.
Zuma's lawyers argued that former Correctional Services Commissioner Arthur Fraser acted within his power when granting the former president medical parole. They say Section 75 of the Correctional Services Act gives the former commissioner the final authority in such matters. Fraser granted Zuma medical parole in September, 2 months after he was jailed for 15 months.
If there is a specific section that says the National Commissioner and specifically excludes all these other people, excludes the minister, excludes the parole board, excludes everyone, may grant parole for prisoners who are serving a sentence of less than 24 months. Then that must be given effect to. Otherwise, those words are meaningless. It means that section is just there for decoration.
The facts are not only dead against the National Commissioner, Lord. The facts are dead against Mr. Zuma. Mr. Zuma's own evidence in this case is an own goal, and my lord found that. Because in this case, Mr. Zuma's counsel repeatedly forgets and fails to deal with the fact that the medical parole application form that was filled in on his behalf was stated to be in terms of Section 79 of the Act.
Senior counsel representing the Correctional Services Department argued against Zuma being sent back to jail, saying that the former president did not place himself on medical parole.
This Medical Parole Advisory Board made a decision that the third respondent was stable. That's all that it says. It didn't say that, after all, he's not terminally ill.
After hearing all the arguments, Judge Mathojane listed multiple reasons why another court may come to a different conclusion from his own on Zuma's medical parole.
His illness and advanced age. What I want to say is because of his illness and advanced age, he needs compassion, he needs empathy and humaneness, which is the essence of Ubuntu. In my view, another court may take this into consideration and come to a different finding accordingly.
Judge Mathojane has described Zuma's battle to stay out of jail as an important question of public law. Elias Mathojane for SABC News in Johannesburg.